very, there are probably some very experienced practitioners online, and there are probably people who haven't done any landlord tenant work uh, as part of this. So I'll try to keep that in mind. But I would just say two things before I launch, or before Jed and I launch into the PowerPoints. Um, you've all dealt with clerks of court at all levels, municipal court, common pleas, other counties, federal court. You'll have to get a sense of the clerk of judicial records in Philadelphia and the personalities you're dealing with. It's sometimes a moving target. We will tell you what the rules say, the local civil rules, as well as the rules of civil procedure. But then there is the reality of the person behind the desk who may have their own rules, and you'll pick your battles, pick your fights. You don't want to give up on anything essential that you have a right to do, to file in a timely way and below a deadline. On the other hand, you don't want to spend a lot of time educating somebody in the clerk of judicial records and winning the battle and losing the war. That's all somewhat vague, but I would urge people to be practical, do a practical overlay in all these filings. So Jed, do you want to speak a little bit, give a minute or two, and before launching into the blow-by-blow PowerPoint?
Yeah, I'd be happy to. And I think the point that I would make is largely the point that you made, Mike, which is that you're dealing with the clerk of judicial records, and you should expect that you might run into some roadblocks. And it's a good idea in dealing with appeals, but anything really in the Philadelphia Court of Common Pleas, to assume that you might run into a roadblock here or there, and build in extra time into your schedule to assume that you might get something kicked back, and you might have to call the clerk and explain things. And even if you're right, the clerk might tell you to do it somewhat differently, and sometimes you don't want to fight City Hall. Just go with the flow.
Hey, Tom,
but if you have 2 or 3 extra days in your time to file your notice of appeal, that is tremendously helpful and will reduce a lot of the stress of the process.
I certainly second that. Last minute appeal is usually more stressful. So I like to not do last minute appeals, although I sometimes do and have to. And keep your eye on the ball, because you think you have filed something. Check that darn docket, keep on top of your emails, make sure that it's filed, make sure it's up on the docket. Your notice of appeal probably being the most important thing in the rule to file complaint. So check, keep on top of it, because you don't want to miss a deadline. And as Jed says, it might not be your moment to convince somebody of the literal reading of the rules, because you don't want to lose the battle, or win the battle and win and lose the war. Okay, time for filing appeals. Judgment for possession and money, 10 days. Once upon a time, it was 30 days, but it's 10 days where possession is at issue in the residential lease. Not a commercial lease, not a non-residential lease. They still can have their 30 days, I believe. But if you're representing tenants, and as we do, low-income tenants pro bono, 10 days is you don't play with that. It's your statutory appeal deadline, and you can sometimes file a nunc pro tunc motion for a late appeal, but the legal standard for anyone who's had the unfortunate experience, it's pretty tough. So 10 days, mark it on your calendar, write it on your arm, make sure you don't miss that 10-day appeal period. It's absolutely essential. Money judgment only. It's been a muddied area over the years, and it took, I guess, Superior Court cases to straighten it out. But for right now, if you're appealing money only in a residential lease, you have 30 days to appeal it. We and I like to consider the 10-day period as a drop dead time period if possible, but you do have 30 days to file a money only appeal. But if you file on the 11th day, you're only contesting that $5,000 rent judgment. It's too late to fight to keep your client in the place, to keep the roof over their head. And the civil rules, the local rules are cited there.
Mike, I would just add that this is probably the most important deadline that you deal with, because as you noted, it is jurisdictional. Once you have a valid appeal going, if you file something and you get it kicked back and you have to refile, chances are that you can get through that without any adverse consequences. But if you miss the deadline to file the appeal itself, you're not going to have a valid appeal, and you don't want to be in a position of fighting a nunc-pro-tunc battle, because it's just a lot of effort and low likelihood of success. So, if you're representing somebody and they want to appeal, file it the day of, file the day after the judgment. Get it in there so you don't have an issue.
And I would add, if you're not sure you're going to take that case and it is the 9th day, send the pro se person over to City Hall. Let them file the appeal. If you can't commit right now, send them over there to get it filed pro se. You can enter your appearance the next day, but if you don't make that 10-day, it's game over. Yeah. And there's the handy dandy pre-printed form, and you can see it has the blocks for the type of appeal: residential lease 10 days, non-residential 30 days. It always has me scratching my head as a CLS person, why the General Assembly in its wisdom, and then the Supreme Court had to ratify their legislation, essentially, why they shortened the appeal period for residential people to 10 days and left 30 days intact for non-residential. In my very subjective, very biased opinion, the roof over somebody's head is a whole lot more important in most cases than that commercial lease. Nevertheless, that's the law out of Harrisburg. We litigated it years ago, long time ago. The General Assembly changed the then 30-day appeal period for all appeals to 10 days, and they boosted the escrow requirement for supersedious, which we'll get to in a minute or two, from just ongoing rent to 3 months rent. We litigated that in the Eastern District, and we got half the loaf, a big important half of the loaf. The Eastern District knocked the escrow down for poor people to 1/3 of a month, and I'm getting ahead of ourselves, but they left intact, contrary over our due process equal protection attack, they left intact the reduction from 30 to 10 days. So 10 days is what it is, folks, and that's what, for residential appeals, that's what we got to do.
Hey, Mike, before we jump in a little bit further, does it make sense to talk about why you might want to file an appeal? Because I think the strategy question is important.
Yeah,
and
here's people who've spent legal services and time like I have. We tend to wax on with too often boring stories and old war stories. But years ago, I worked at a public defender office in New Jersey for a few years. And occasionally a client would say to me, when I'd say, well, what do you want? Essentially, I want my trial. You do not want your trial. That's not what you want. You might want an acquittal. You might want probation. In our case, you might want to avoid eviction, but you don't just want a trial. So we file keeping our eye on the ball. What do we want? We want to avoid eviction. We want to knock down an unfair or eliminate a money judgment. Keep in mind what you want, in my less than articulate way. The appeals often present the opportunity to reach a decent settlement. Like most courts in the land, most cases settle that are appealed from municipal court to common pleas. But without throwing in whatever the right metaphor is, monkey wrench is too crude, but without stopping the eviction mill, there's no reason for the other side to talk to you. So you can look at this appeal in a few different ways. It's a de novo appeal, so all bets are off. It's a new record. Everything must be proven again. But you may have a clear case. Well, I should win this case in a heartbeat. The facts are so clear. Most cases are not that kind of crystal clear, but you may be looking at this. I have a client who's going to be evicted in a week or two, who's got a couple kids, who's got a lot of health problems, has legal defenses, but part of the thinking on the appeal is we can set it up to have a dialogue, a discussion with the other side. I'm not saying we'd ever file a frivolous appeal without any grounds whatsoever. We wouldn't do that, but it often presents the opportunity, the appeal, to slow things down, to stop the eviction, to get people talking again, because sometimes municipal court is not the best place for people to talk and then to negotiate. Let me clam up for a minute, Jed, and let you take over.
Yeah, I think the other thing that I would add, and you touched on it, is time. The municipal court process is fairly quick. You get to a judgment pretty quickly. A lot of our clients, they might have defenses, they might not, particularly if it's a payment of rent case and they just don't have the means to pay that rent. But one of the things that they often need is a little bit more time to get their affairs in order, get the money together to put a deposit down on a new place, and have an orderly move as opposed to an eviction. And filing that notice of appeal and litigating the appeal and or talking and reaching an agreement can give you those couple of extra months that might make all the difference between an orderly transition to other housing. Absolutely. And a chaotic one.
Absolutely. It makes the difference between moving into the shelter system for a year and landing on your feet. Maybe not a perfect life, but a roof over your head. We know that when a person loses that roof over their head, very too often they lose their job because they can't shower and get to work on time. Sometimes they lose their children because DHS comes out and says, we can't have you in this awful situation. So their lives can really collapse, and their lives won't be perfect with this. But I would add to what Jed said, there's almost always something that's an appealable issue. And again, I'm a tenant advocate, but everything from late fees to attorney's fees to excessive rent that should have been abated, there's almost always a basis for an appeal. And as Jed points out, it can make one heck of a difference. It's an exaggeration to say it would save somebody's life, but it could really prevent it from really going downhill rapidly and for a year or two or more. Yeah. So it's really important.
I guess on that note, I think we should move on to supersedious, which is another powerful tool.
Yeah. And the supersedious, as you see, for low-income tenants, and basically the court has been using PHA income guidelines, which even tend to be a little more generous than IFP for other purposes and other court hearings. As I mentioned earlier, there was a time when the tenant had to escrow only the ongoing rent when they filed an appeal. No past rent, no rent down at the time of filing. Those days are gone. And there was a time, if you're not low income, you still under local rule, civil rule 1001 and 08, 1008, you, as a non-indigent person, you still have to put down the lesser of 3 months rent or the amount of the rent judgment in municipal court. So most of VIP clients and COS clients, we almost never get somebody who's not eligible for this, but occasionally we do because somebody was laid off and they were not laid off. It's an emergency, it's a health emergency. So maybe in decades, we won't get anybody who there's a question about whether they comply for this. I mean, 99.999% of our clients will be eligible for this reduced escrow amount. And it's serious business. Your adversaries, some of the landlord-tenant bar will literally evict your client if they're a day late or $1 short on the escrow. So it's something you really want to focus your attention on. Make sure they make the correct initial deposit and make sure they make the correct deposit every 30 days thereafter. Because believe me, I've seen landlord lawyers run in with the precipice the very next day, and it's really hard to deal with that. Even if the client has the money, comes up with the money, a motion to reinstate the supersedious is tough. In Allegheny County, we can dream on, but before a supersedious is terminated, Philadelphia is a simple precipice, and the prothonotary looks at the record and says, yeah, the money's not there, supersedious to stay is terminated. Allegheny County, you have to give a 10-day notice, give the tenant a chance to explain or contest it. That's something that we could advocate for in Philadelphia. We don't have it now. But that's roughly, I can't overemphasize the importance of getting the escrow right. The IFP will not waive your escrow requirement. That's been up and down in every court in the land, and they won't waive this supersedious. But Jed, what are you thinking?
Yeah, so I think two important things that you touched on there, Mike. One is that the supersedious, there's a right to the supersedious if you comply with the escrow requirements. So it's not something that you have to go into court and ask the court to enter. You know, you can get it automatically provided that you are timely with the escrow payments. So, you know, it's different than having to make a motion for a supersedious. All you have to do is comply with the escrow requirements. The other point that you made is that it's also fairly automatic to terminate the supersedious if you do not comply with the escrow requirements. It's a precipice, and the clerk will terminate it as a matter of course, you know, upon filing the precipice if the escrow is not there. So it's automatic upon payment of the escrow and maintenance of the escrow, but it's also fairly automatic upon failing to make those ongoing escrow payments.
And I would add, as a practice point, during the pandemic, things have gotten a little crazier at the Clerk of Judicial Records. You really have to stay on top of this. I mean, there was a time when you could file most things electronically. We've had a couple cases in the last couple of months where the person had to make an appointment to go over and deal with the supersedious, and even to file the notice of appeal. When things were operating normally, the only thing I had to file electronically was by paper/scanning was the notice of appeal and the rule. You could just check the box for the supersedious, the rent deposit. You could put a credit card online. They had a system, they had it organized. You could file today, and the tenant could appear at the counter tomorrow and put the money down. And but you can't overemphasize the importance of it. A couple quick points. If the tenant won below, it happens occasionally, and the landlord is appealing, you don't need to put any money down. Okay, there we are, the exceptions. But might as well read them. You can get that a lot more efficiently than I can say it.
I'll just add that once that supersedious is terminated, the landlord-tenant officer can come out to the client's house and lock them out. So it's definitely something to discuss with your client if they can continue making those payments to keep up with it in time for the appeal hearing to come up, or if that's just not going to be a possibility.
And as Jed pointed out earlier, the catastrophic, or at least very serious consequences of an eviction, the eviction, you get 10 minutes notice basically before a lock is put on the door. I mean, you might get something in the mail, you might not understand what it is, or you might, but many times tenant doesn't know what's going on, especially an unrepresented tenant. Supersedious is terminated, which means municipal court judgment can now be enforced, which means they go through the landlord tenant officer. And when they come out and knock on your door, they say, you have 10 minutes to grab your medication, your family photos, your money, whatever. And then they put a lock on the door. So you want to talk disruption of your life. I think anybody can imagine if we had to move within 30 days. But if you're moving with the real practical understood notice of 10 minutes, your life, you're really in trouble. So yeah, circling back, can overemphasize the importance of maintaining those payments and maintaining the supersedious thereby.
And one other point, and it's here on the slide, is just that even if you have a judgment for possession only in municipal court, there are going to be ongoing escrow obligations to maintain a supersedious in the Court of Common Pleas. So even if there wasn't a money judgment below, you're still going to have to be putting money into the escrow to maintain a supersedious on appeal.
Yes. Yeah, the only difference is you don't have to put the money down when you file, but so the precipice rule, the rule to file complaint is important to, like most technical filings. I've seen people's appeal dismissed because they didn't file a rule through the same lightning system. Landlord pro se or landlord's attorney shows up with a precipice and has it dismissed. So make sure when you file your notice of appeal, you file the rule to file complaint. I mean, the secondary consideration, if you don't file that rule, the landlord is not under any pressure to go to the next step and file a complaint because there's no rule ordering the landlord to do that. And then service has to be made. It's a game, and a game is a poor word. Some people approach it that way. There are so many technical pitfalls for a tenant, especially a pro se tenant, and a big segment or some segments of the landlord bar, they do not hesitate to, they'd much rather win a case through filing a precipice than going to a bench trial or a jury trial. So let's see, tenant supersedious. The irony about the pro se filing, a tenant has to jump through many more hoops to get the IFP, for example, and the supersedious affidavit. When there is counsel, Pennsylvania Rule of Civil Procedure 240 basically says if counsel for the appealing tenant files a simple precipice saying, I'm doing this for free and I believe my client cannot pay, that it's filed. There's no, you might have somebody at the counter or the electronic counter telling you you have to do the full affidavit for the IFP, but that's not true. Now so the attorney, the great irony, attorneys can have a much easier time for the client than a pro se person fumbling around. Okay.
And just one other point here when we're talking about the rule to file complaint. For those of us that regularly practice in Court of Common Pleas, I mean, the process once you have filed the notice of appeal is generally pretty similar to a standard civil case. It's as if a case was commenced by a writ of summons. You have the rule to file a complaint. The landlord files the complaint. You file your preliminary objections or your answer. You have you get a hearing date, but it's very similar to a standard civil action.
And I would say I have no interest in PBI or any other CLE, but the Civil Practice Manual, which is a big fat 3-ring binder and usually used to come with the CD-ROM, now I guess there's a flash drive, is an incredibly good resource for any common pleas case you're doing, including landlord tenant. So if you have one, I would refer to that. If you have access to one, get to it and consider purchasing the civil practice manual. I think it's invaluable. Each section, you know, first filing, discovery, appeals, and a host of forms for all the things we've been talking about. So we have mentioned jury demand. COS first got, well, we've been requesting jury trials for years, and we have them once every 5-10 years. They don't go to trial that often. They often go to jury selection and somewhere in the process. But frankly, most landlords don't want to try a case to a jury, and they tend to get very reasonable in the home stretch. But sometimes, and for me, it's been literally when the jurors file into the back of the room and you win a couple motions in limine and then you resolve it. But the jury demand is something to seriously consider in all your cases, because if you don't file within 20 days of, I guess, when the last pleading is due, you'll forever waive it. Now, one wrinkle about the jury is when you file it, my reading of the rule, there was a time when you could withdraw it as long as the other side didn't request also. But my reading of the applicable rule is that once filed a jury demand, all parties have to agree to withdrawing it. But jury demand is a powerful tool, a powerful option. Whether you ever get to a jury trial or not, it's something that you should seriously consider. And if you are filing IFP, and if you are attorney just clicking on the box for the IFP, you don't have to lay out $200 or $300, whatever it is now, for a jury demand. So I would seriously consider it in all of your filings.
Yeah, I would agree with that. I mean, I think, you know, one way to think about it is that, again, this is a very streamlined, quick process in municipal court. And you know, frankly, a lot of the work is volume business, where somebody is processing a lot of these complaints. And you know, the premise of the business is to process the complaints quickly. A jury demand makes it a much bigger, more serious case, and changes the dynamics and economics of the proceeding. So it's very powerful in that way.
Yeah. And one final little note, we did it forever, even when appeals first went from municipal court to the arbitration center and then to a bench or jury trial. But there was a period of years when it really accelerated, because the judges of municipal court were hearing appeals from municipal court. They were temporarily assigned to common pleas. And that made for an awkward system. At the time, Judge Moss and other judges before him were hearing municipal court appeals. And as long as they didn't sit below, and actually there were a few cases where they were hearing cases where they did sit below, and if it was a pro se litigant, not sophisticated, it was a funny world. So yeah, jury demand, something to think about for sure.
Yeah, so the appellate process, this kind of touches back on what we were talking about a few minutes ago, which is that, you know, it really is, it's a de novo process. It really is a full civil action. You're going to get a case management order upon filing the notice of appeal. That's going to give you your deadlines, including your settlement conference, your trial ready date, and, you know, kind of the roadmap for what your case is going to look like in Court of Common Pleas. It is, you know, a standard civil proceeding, as opposed to, you know, again, the very very abbreviated municipal court process.
Yeah, and all those forms will be on the docket as PDFs, including a form you fill out for the settlement conference. Yeah. Here we go. Yeah. and my experience has been a range of experienced mediators. I don't think they call them judge pro tem, although they might. Uh, it's worth going to no matter what, and in fact, you should be there. I haven't seen landlords sanctioned for not showing up, but it's a good vehicle. I think whatever forces you to sit down and talk is usually a good thing.
And Mike, do you have a view on whether your client should attend the mediation or the settlement conference or not?
I like my client to be there, although, as you know, it can sometimes be a very volatile situation when landlord and tenant are in the same room. I've had some really interesting ones where people almost had to be separated. But I like to. I'd like my client to see what's going on and know what's going on. And it's one more, it's not a legal reason per se, but it's one more opportunity I have to sit down with my client, talk about the options. I guess at the minimum, and I don't know, I guess the requirements are, like it says, you should be available by phone. I mean, sometimes I guess there might be tactical reasons why you don't want your client there and be available by phone. Sometimes your client just has an emergency and cannot make it. But I like my client to see what's going on, to be part of the process, and to not have a fear that things are going on without their knowledge, you know, and that's often a danger in our business, I think, because the system has been unkind to people for a long time, and there's not a lot of trust. So if for no other reason or one additional reason, I like to have my client there so they see what's going on.
And I would also add to that, if you have a realistic chance of having a real conversation and maybe getting to a mediated result, it's very, very difficult to get to that if you have to keep stepping out of the room to talk with your client on the phone and explain, you know, what the offer is, why you're telling them this offer, what it means, all of that. It just, you know, these are, you know, these aren't full day scheduled mediations. They're fairly quick process. I mean, it might be an hour.
Yeah.
They might give you an hour, but it's very cumbersome to be stepping in and out of the room to try and talk with your client about these things. So if you really want to try and get a settlement done, I think in almost every case you want your client there, unless it's just going to be such a volatile situation that, you know, people are going to have to be restrained, and you're not going to be able to approach things with reason rather than you know, passion.
Yeah, I agree. Well, I like preliminary objections, POs. They're not available in every case because you have to have some basis for them, but it's sort of like more than one bite at the apple. And a few years back, you didn't even have to file a memorandum of law, which doesn't have to be very complicated anyway with the POs. You just file the POs. They were especially useful if you had a basis and it was the last day for an answer. They were very useful POs. But I find preliminary objections to be useful in many cases because it forces the landlord to produce more information. Now, it might make the landlord better prepared, like some interrogatories, but I don't worry about that too much. But for example, in my mind, there are at least two categories: the sort of technical preliminary objections based on, although the landlord or the landlord attorney mentioned a document in paragraph 1 and didn't attach it and didn't explain why they didn't attach it. That's a PO. That's a preliminary objection based on the pleading. God knows if they don't have a wherefore clause, that's a preliminary objection. If they don't have numbered paragraphs, that's a preliminary objection. But then you can also, you're supposed to put all your POs in one PO filing. So you want to know, you want to object if they didn't have a certificate of rental suitability, if there's no license or substantive defenses or quasi-substantive and procedural. So I like POs many times. I think it's another bite at the apple before the landlord has to file a new and better complaint. Landlord has to give information. Landlord or landlord lawyer has to talk to you and say, work this out. There's a lot of benefits to it. There sometimes in a well-drawn, well-drafted complaint, there's no basis for POs, but I would say almost in a majority of complaints, there is a basis for some PO.
I would agree with you on that.
And again, if the court says no, dismiss your POs, denies them, then you have the option of answering, or the obligation and option of answering. So nothing too much lost other than your time, I guess.
So there was a question in the chat. Can you expand on the basis for the preliminary objections?
Well, defects in the pleading are, you can look at your rules of civil procedure on the filing requirements, numbered paragraphs, verification. Maybe a verification is missing, and that's a preliminary objection. Maybe something's not signed, documents not attached, and maybe you want to see those documents. So it's a way of forcing discovery. But I guess they just break down into those two categories: the sort of technical flaws in the pleading, and then the more substantive. I think it's legitimate if the landlord did not attach a license or certificate of rental suitability, things of that nature. So those are the main things in my mind, the ones that commonly come up, at least. I don't know, Jed, do you have a more of a range of POs?
No, I think that's right. And just one comment on the documents. To the extent that a complaint in Common Pleas references a document as part of the claim for relief, that document is supposed to be must be attached to the pleading, or the pleading must allege why the document is not attached and set forth the relevant portions of the document. So if there's a writing that's referenced in the complaint, it really should be attached. And if it's not, that's a PO I think that you would find being granted.
And we had a strange situation. We have many strange situations in this business in these cases. But some years ago, and there were local municipal court rules that somehow governed the appeal rather than local common pleas rules, 310, 311, whatever. And the rules said you could file as a landlord, as a plaintiff, you could refile your municipal court complaint, just attach that, and that could be your complaint in common pleas, which was a little bit crazy, but it was the local rule, the municipal court rule on appeals. And we would routinely file preliminary objections to that because it wasn't formatted like a common pleas complaint should have been formatted, and they were pretty routinely granted. And then finally the court changed the rules. And I don't know, did we mention in the materials the other kind of appeal, or do we want to go down that road? The appeal of a default when the municipal court, again, I might be getting left field here, and I'll look for a ruling from you two whether we should. But there's another kind of appeal that 66 counties in Pennsylvania, if you don't show up at the landlord tenant court, which is the DJ magisterial, the courts in 66 counties. If you don't show up in those counties, you can file a de novo appeal. As those of you who've done this work know, in municipal court, if you don't show up, you have to file a petition to open that default judgment to get back in court. And if that is denied by the municipal court, you appeal that to Common Pleas, but it's a little bit different under the rules. It's called a supplementary appeal, I guess, in 1001. And there's no automatic supersedious by just putting your money down. You have to apply to the court for supersedious in that case. And it's not a de novo appeal. It's an appeal basically error of law, abuse of discretion. So I don't know how much we want to get into that, but just know that the rule provides for different procedure if you're appealing a case that was not the result of a contest with everybody showing up, but you're appealing a case fault when someone didn't show up, and that could be the landlord, but it's mostly the tenant.
I apologize. I missed one of the follow-up questions as to whether something you were saying about the preliminary objections would apply to ledgers. Was that attaching them to it, or if there was something wrong with it?
So I would say that that's probably, I would definitely think that that's PO worthy. Whether or not rule requires a ledger to be attached, I'm not exactly sure, but I think it's certainly something that could be raised and something that might be granted. I mean, if it's in writing and it's not attached, I would be more than comfortable making the preliminary objection.
Yeah, no, I agree with that. And it seems like the paragraph that demands the rent would have to get close to invoking the ledger or implying or directly. So I think there would be an excellent argument that by demanding the $5,000 for May, June, and July, and there's some reference to a record and it should be attached. So I would be going with that too.
Okay. Excuse me. May I ask you both to just do a brief overview of the de novo trial? How does that differ from the municipal court trial?
Well, it's very, over the years, I think it's been very judge specific. Some years you hardly recognize the difference, and you especially had a hard time recognizing the difference because there was a municipal court judge sitting on the bench presiding. But you have it's a different procedure, different animal, because you have motions, you have discovery, which you don't have in municipal court. So I try to do decent or somewhat extensive discovery or minimal, depending on the case, ahead of time. But then there's, if you have motions in limine to bar, the introduction of certain evidence, maybe based on your opponent's failure to provide it in discovery, maybe on other grounds. So I think some of the big differences are based on the motion practice that you don't have, and the extensive pleadings. There's no responsive defendant pleading in municipal court. There's no answer. Counterclaims you can do orally for up to $2,000, even on a day of court. But for more than that amount, you have to do it in advance, 10 days in writing. But and of course, if you go down the jury road, then it's looking a lot different because you have all your jury materials, you submit your points, and this would be in the case management order. It does deal with jury very briefly, just a paragraph or two, I think, but it will tell you that you have to provide points for charge, jury instructions, etc. So if you go down the jury road, it's going to look a whole lot different. But I think even a bench trial in Common Pleas is going to look different than it once did. It's so judge specific because, like I said, we once had municipal court judges hearing their own appeals. We had a judge, I don't want to get too specific, but we had a judge hearing these cases who sometimes made the municipal court process look like federal court because it was so brief. I better turn this over to Jed before I get myself in real trouble. Jed, how do these trials differ? Let you take that.
So I guess just kind of stepping back logistically, my experience has been, you get your trial listing, assuming it's a bench trial, you get your trial listing and you show up on that day, and there are, a number of cases on the list, and the judge kind of statuses the list and then, starts hearing the cases. And I thought that the bench trial in common pleas was fairly similar to a bench trial in municipal court. It's probably a little bit more formal on the application of the rules and things like that. But it's a bench hearing. Has that been your experience with how the actual day of trial goes?
And you mentioned the rules. I guess the rules of evidence are somewhat more recognized, but yeah, it was so judge specific. I mean, we have judges who treat it, I'm searching for the right diplomatic words, very seriously, and some judges, I don't know, treat it differently. And of course, with the jury, you get the message at every critical stage. Sometimes you got to be kidding me. You're going to take this case to a jury. Not quite. No, you're not. But some judges just do it by okay. You requested a jury demand. I'm a judge. Let's roll. Let's do this thing. But anyway, it varies depending on. It looks like municipal court. It doesn't look like municipal court, and it's a lot judge specific.
Thanks for that. I appreciate it. So we have a couple practice points. So Mike, I know you were beforehand. You mentioned the unwritten rules. Do you want to talk a little bit?
Yeah, it's so. One thing I've learned over the years is court staff, courtroom staff, the people who pour the water pitchers or the people at the counter can really make your life miserable and can really hurt you. It can make you look foolish at trial. So you want to take your basic personality with you. You treat people nicely in your non-legal world. You especially want to do that in the legal world. You have to pick your fights, in my opinion. What's it worth to you? Somebody says, "Oh, you needed a blue piece of paper, not pink." Okay, I'm down with that. I'm joking, but you have to pick your battles. You don't want to let somebody bully you that you're going to blow a deadline or you're going to jump through crazy hoops. On the other hand, you don't want a Pyrrhic victory where I really rubbed this court staff person's nose in this, and they agreed that I have to do this. Well, guess what? The next time you file something in that case or another case, it's going to have some consequences. So it's picking your fights. Take your basic personality that treats people very well and treat people maybe a little bit nicer in the system. Work with their stubbornness. I know this is not very specific, but it can make all the difference because now may not be the time to educate court staff on the rules of civil procedure. Now may be the time to say, oh, you wanted one more piece of paper. I just scanned it and it's over there now. You want to get the darn thing filed. And I guess these things happen less in other courts. But these are something to keep in mind. And I see the mention of COVID there. I've had a couple colleagues with really kind of crazy experiences, and you have to make appointments now, both as a pro se litigant and maybe as counsel going over. And sometimes you meet somebody who doesn't know the escrow rules if you paid rent that month. And so hopefully you can do most everything electronically, and that's the way to go. If you can, if you can just click I am proceeding IFP or I'm applying IFP, you click that and move on. I am requesting a supersedious, you click that and move on. um, so yeah, not super specific, but use your head with dealing with these situations. Figure out what's really important. Figure out when to make your stand, and when to just say, okay, you wanted a different kind of paper clip. Here it is.
And Mike, if I can make the point, the flip side of everything you just said is also true, which is particularly when you're dealing, when you're in court for trial or things like that, the courtroom staff can often be very helpful in answering questions. And as you mentioned, the procedures are often very judge specific. If you have a sense as to what you're expecting, and you get there early, you might chat with the courtroom clerk and say, hey, this is how I, am expecting things to go. Is that typically how Judge so and so does things? And you can get some very helpful information from them, and particularly courtroom staff. Some of them are grouchy and not helpful, but my experience has been many of them are actually pretty friendly and helpful, and are willing to help you, make sure that you understand what the process is going to be. The other thing is, I'll just go back to, you talked about the unwritten rules. There are a lot of those unwritten rules, and a lot of them are collected in that Philadelphia Civil Practice Guide that you mentioned. So, if you're looking to try and at least find out some of those, that's a great place to start, to get some of that intel.
And I would add too, I agree with all of that. And if you do have the odd case once every bunch of years, and it's going to be in front of a jury, boy, that court staff can make you look good by calling you Mr. This or Ms. That, or they can make you look like a fool without even trying. So all the more reason, like you say, somebody's a grouch, they're always going to be a grouch, so you treat them with as much courtesy as possible. But if you can get a rapport with court staff, either at the desk filing, next time you have a problem, you call Joe or Mary and they cut right through it for you, or in the courtroom, like you say, check out the lay of the land. So yeah, I agree.
And particularly when you have a jury case, remember that the deputy clerk is the jury's best friend, who is, may have a hand in helping you do jury selection, is the person who's explaining things, to the jury, taking them in and out of the room. That is the person that, other than the judge, the jury is going to look to for just guidance on what they should be expecting and how people should be behaving in the courtroom. And so, being a friend and a colleague to that person, and having them, show, make you look good in the jury's eyes, on these procedural and technical things, it's very valuable.
I agree, and I see it on the chat, and that Kay said that some judges' chambers now have courtroom rules in quotes, so that's a good thing to check for. This is my fault more than anybody's with my wandering. I did say I had to leave at noon. I'll stick around a while longer. Where are we on the PowerPoints? Do we have a lot to go?
No, we're on questions. So
okay,
you have to leave, you can, but I do want to just take a quick moment to say thank you both, Mike and Jed, so much for doing this presentation.
I have a lot of questions. I just wanted to stay on and ask my questions. No, yeah, I'm sorry. But it's good. We got through it. So yeah, I'm available if you want to send me questions that come up. And I think part of the value of this thing is just knowing what to ask, knowing when you have to research something, knowing when you have to call one of the folks who do landlord tenant law. And the materials are great. So, and again, I can't overemphasize that civil practice manual. If you can afford it, if you have access to it, it really tells you one heck of a lot. So I'm going to sign off, but I'll keep on, I'll look for, you know, questions that come in later and provide materials or whatever else. But thank you for the opportunity to do this. I appreciate it.
Yes, thank you very much for the opportunity. And you know, as with Mike, if anybody wants to send me questions, I'm happy to respond to them.
All right. Bye.
Bye, everybody.
Bye.
Thank you.
So I will stop recording, and if anyone has questions, feel free to let me know. I am happy to forward it to our presenters. Let's see. Stop recording.